many unsavory remarks of sections to the populace, particularly personalities in the NDC. Since leaving office, I have also stayed clear of subjecting the work of my successor to any form of assessment, leaving that to sending Ghanaians to do. Before this morning, I had made absolutely no statement or comment whatsoever about the conduct and performance of the new Attorney General, Dr. Dominic Ayine. However, at the press conference of the Honorable Attorney General, in a rather unconventional manner, he proceeded to malign my good self, immediate past Attorney General, and peddled a host of untruths, half-truths, and misinformation. A trajectory which is not only unfortunate, but begs the question as to the true motives and justification for his decisions. The judiciary was not spared the brush of the Attorney General's unwarranted scathing attacks, as some members were subjected to similar disparaging attacks under the guise of Dr. Ayine's strained exercise of assigning reasons for decisions he has taken as Attorney General. I consider the attack on the judiciary as part of the stratagem of the NDC to blame others for their resolve long before they assumed power to clear all of Joe Mohammed's appointees of any criminal liability for past acts by withdrawing criminal cases pending against them. Indeed, Dr. Ayine's decisions are in furtherance of the resetting agenda of the NDC. The material facts will bear this out. Dr. Ayine was sworn in as Attorney General on Wednesday, 22nd January 2025. On Friday, 24th January 2025, he caused to be filed a notice of abandonment of the appeal by the state in Republic vs. Atuforsin and two others. On Tuesday, 28th January 2025, we withdrew the case against Dr. Sibnopuni and two others, resulting in the complete whitewash of their crimes by an acquittal and discharge through the back door. On 29 January 2025, he entered another withdrawal in Republic vs. Kosovo and another, again resulting in an acquittal and discharge of the accused. On 30 January 2025, Dr. Ayine withdrew two different cases against Dr. Johnson Pandit December, resulting in his acquittal and discharge in one and a discharge in the other. There were more withdrawals and non-prosecuted to be entered by the NDC government through the Attorney General in the subsequent days. Indeed, what grew the trend of one day, one withdrawal was the occurrence of witnesses. Ladies and gentlemen, these developments irresistibly point to only one conclusion: a calculated, preconceived ploy on the part of the NDC to wipe out all criminal cases pending against its leading members and officials of the John Mahama government and clear them of wrongdoing not by the court but through their Attorney General. Remarkably, there is no precedent for this kind of conduct in the Fourth Republic. Throughout the two 8-year terms of the MPP in government, no Attorney General appointed by either President Yeboah or President Godfred withdrew criminal charges or filed non-prosecuted in cases involving leading members of the MPP or senior members of the government. By the time the MPP assumed office in 2017, all the cases filed by the erstwhile NDC government against some ministers of the before government and other appointees have been contested fully in the court and won. We secured acquittals through the court, not by resorting to delayed tactics, in the hope that the Godfred appointed Attorney General would come and withdraw the cases and procure an acquittal. I speak from experience as I personally conducted some of the cases. Other lawyers within our ranks, including my colleague Deputy Attorney General, also handled same. I must state that it is clearly unprecedented for an Attorney General to hold a press conference and subject his predecessor in office to abuses and peddle falsehood in the manner displayed by Dr. Dominic Ayine. I'm constrained to set the record straight, to unveil the half-truths and manipulation of facts for 1 million Ghanaians to decipher the true intentions of the NDC government acting through the current Attorney General and withdrawing charges against leading members of the NDC. One, it is necessary to indicate at the outset that the decision to charge a person with a criminal offense, especially the high-profile cases at issue, which have serious implications for the public purse, involved a prosecutorial discretion exercise pursuant to painstaking investigations conducted by duly authorized investigative authorities of state, inquiries and extensive deliberations by career prosecutors prosecutors in the office of the Attorney General, who indeed proceeded to conduct the cases themselves. I continue to be grateful for the advice I received from the hard-working attorneys at the AG's office, investigators and my able deputies, Mr. Yeboah and Mr. Nasnomadapa, on the cases we personally initiated in office, and the many others that have been commenced by my distinguished predecessor, Madame Gloria Yeboah, which will continue. We cherish the robust discussions and debates we had whilst professionally moving forward in each of those cases. The nation would note that Dr. Ayine and other leading figures in the NDC and the government of the day were counsel in many of the cases he has discontinued. I say that indeed it is not uncommon for defense counsel as Dr. Ayine and other NDC personalities work, looking at the same set of facts to come to different conclusions, informed by their varying understandings of the law and, of course, the undeniable political considerations they hold. However, I dare say that in taking decisions as monumental as drawing those cases, the only consideration has to be the national interest and not that of defense counsel. The analysis I make of the reasons advanced by Dr. Ayine will expose the questionable intent behind the withdrawal of the criminal cases. Dr. Ayine's unfounded allegation insinuating unethical conduct on my part in the conduct of the ambulance trial, Republic vs. Successor, 2000 and two others, is highly disingenuous and rather unfortunately recaps a series of falsehoods persistently published by foot soldiers of the NDC and other uninformed members of society. I must say that I find it quite ironical for Dr. Ayine, who is the subject of disciplinary proceedings for professional misconduct, still pending at the General Legal Council, filed by the Honorable former Chief Justice himself, to accuse him of unethical conduct. In the interest of the nation, the case of professional misconduct pending against Dr. Ayine at the General Legal Council should have been determined before the parliamentary assessment of his suitability or otherwise for the higher office of the Attorney General and Minister for Justice of the Republic. The facts relating to allegation by Dr. Ayine that I interfered with an accused person in the ambulance case are well within the public domain and have been adumbrated in court proceedings. The record shows that there has been a judicial determination of that unfounded allegation frequently made by foot soldiers of the NDC and other uninformed people. Shockingly, Dr. Ayine, the current Attorney General, ignored this fundamental fact in his 10-page press statement and over an hour conference with the media for the simple reason that he knew that his allegation had been flatly debunked by the courts when same was put to scrutiny. If you would recall, the accused person in the ambulance trial filed an application for mistrial, hanging same on the alleged interference with one of the accused persons. On 6 June 2024, the High Court quorum or sitting through or presided over by the Chief Justice Efia Sewa Saiboki dismissed the application. You will all remember the learned Justice of the Court for Appeal, who serves as an additional High Court judge, said that she had listened to the tape in question about 10 times and found nothing to warrant a mistrial. Specifically, she stated at page 24 of her ruling, and I quote, after listening to a conversation between the third accused and A1, the issue of whether the Attorney General actually told A3 to implicate A1 is not borne out by the evidence on Exhibit C-AF2. These words were uttered by A3 at about minutes 09 to 10, minutes 10. In the same vein, the declaration that A3 was innocent and was going through ordeal, but was being asked to help make the case to the AG better, was not made by the Attorney General, but was made by A3, to which the Attorney General responded at minutes 10, second 20. And I quote, I am not asking you to help me at minutes 10, second 30. A statement that you and I have been meeting at my cousin's place at minutes 10:45, etc., were quite closely together with A3's alleged attack of conscience did not proceed from the mouth of the Attorney General. End of quote. The judge proceeded to state at page 32 of the ruling that the third accused, and I quote, the third accused by any stretch of imagination is seen to be the one. The third accused by any stretch of imagination cannot be seen to be the one procuring new evidence or cowed by conversation. End of quote. In the face of this clear judicial pronouncement of no wrongdoing as to warrant a mistrial, it completely defies logic and good reason why the Honorable Attorney General of Ghana would say to the public that I was capable of of what he describes as a disgraceful and unethical conduct in the ambulance trial. Ghanaians want to know rather how the current Attorney General, Dr. Dominic Ayine, will deal with the complaint of personal misconduct pending at the Legal Council against him, but no less a person than the former Chief Justice of the Republic. Ladies and gentlemen, in a chilling twist, the nation head Dr. Ayine confessing to speaking with lawyers for the defense and engaging them on the cases that were pending against leading members of the NDC before exercising his discretion to file no prosecution or withdraw the charges. He indicated that in Republic versus Accuses, the lawyer for the accused expressed an inclination to go on and prove the innocence of his client, and therefore he decided not to enter no prosecution. Respectfully, what this betrays clearly is that the exercise of Dr. Ayine's discretion to continue the prosecution of cases or not is informed principally by the disposition of counsel for the accused in cases that the Republic is prosecuting against their clients. Thus, if counsel for the accused is in a position to strongly defend the interests of his clients in court, the Attorney General of the Republic will not enter the prosecution. Where the counsel for the accused are not convinced of the likelihood of a success of their defense in court, Dr. Ayine will immediately enter a no prosecution if the prosecution has not closed the case, and a withdrawal if the prosecution has closed its case, so that an acquittal discharge will be secured. As I will show in an examination of each of the specific cases cited in Ayine's press statement, the Honorable Attorney General quite comprehensively relied solely on the case for the defense before exercising his discretion to discontinue the actions. He did not engage in any meaningful consultation with the prosecution's division of the Office of Attorney General before instructing the filing of the withdrawals and no prosecution in the cases against senior members of the John Mahama government and other leading members of the NDC. The dates of filing of the said processes buttress the assertion I made, and I refer to them already. I challenge Dr. Ayine to show any memorandum presented to you by the prosecution's division of the Office of Attorney General advising or indeed expressing a view on the consultation, discontinuation, or termination, as he calls it, of any of the criminal cases in question. I can say without any fear of contradiction that there is none. He should also show evidence of consultations on any of the charges he held with the Director of Public Prosecutions, the DPP, before discontinuing the cases. You can be assured he cannot produce any. Listening to Dr. Ayine, one gets a distinct and chilling confirmation that he relied solely on the version of the facts as presented by counsel for the accused, as well as their erroneous views of the law and the subject matters in question. It is for this reason that the claims of alleged defects in the various charges only re-echo positions articulated by the defense counsel throughout the various proceedings. In effect, Dr. Ayine came to narrate to the Ghanaian public on Wednesday the perspective of defense counsel, the charges their clients had been charged with. The media will notice that for each of the cases, the explanations of the Attorney General for the withdrawal were only a rehash of arguments already reported in the media as having been made in the courtroom by counsel for the defense. Is that a reasonable manner of the exercise of the Attorney General's discretion to enter no prosecution and withdrawal of criminal cases? I ask. The people of Ghana should be very scared if we have an Attorney General whose prime consideration for the discontinuation of criminal cases involving the loss of billions of Ghana cedis is the position of defense lawyers on charges preferred against their clients rather than the interest of the Republic in the prosecution of crime. Even more scary and bizarre is the claim of Dr. Ayine that he did not consult the former president, John Dramani Mahama, before taking the monumental decisions to discontinue the criminal cases. The cases involved the loss of colossal sums of taxpayers' money, and some related to the banking sector crisis, which affected the Ghanaian economy. The people of Ghana should indeed be extremely concerned and afraid by the vesting of prosecutorial authority in a person who can discontinue the prosecution of such important and high-profile cases without discussing with the President of the Republic and members of the Cabinet. Even defense counsel, according to him, they consulted. How much more the President? But ladies and gentlemen, we ought to ask ourselves, is it true that Dr. Ayine did not consult the President or his Cabinet about the decision to discontinue the various criminal proceedings? A careful examination of the facts shows shows that this claim is palpably untrue. The nation has not forgotten the loud claim by President John Mahama and the NDC that the MPP rather was responsible for a collapse of the banking sector crisis. And that's on assuming power, the John Mahama government will restore all the banking licenses which were revoked. The withdrawal of the cases in question is only the first step of the clearing of whitewashing process of those whose acts led to the crisis that plagued the banking sector. Ghanaians are certainly more discerning than the NDC and Dr. Ayine think. I proceed to examine Dr. Ayine's reasons for withdrawing some of the criminal cases Dr. Ayine mentioned in his press statement. And I find generally that all his explanations are laden with contradictions and inconsistencies and betray the questionable motives for his actions. First is the Republic versus Kessia Tufosin and another case. The first reason assigned by the Attorney General for the discontinuance of the appeal is ethical and professional, since, according to him, he was deeply involved in the conduct of his defense as a defense of Dr. Tufosin. He could not, according to him, in all good conscience, continue the conduct of the appeal. This explanation is a sham, as the Attorney General's prosecutorial authority under Article 88.4 of the Constitution is exercised by himself or, in a quote, any other person authorized by him in accordance with any law. Pursuant to this, the Criminal and Other Offences Procedure Act 1960 Act 30 permits attorneys of the Office of Attorney General and other persons, including even private legal practitioners, to whom the Attorney General may delegate his powers through an executive instrument enacted pursuant to Act 30 to prosecute. Thus, the fact that he, Dr. Ayine, found himself in a conflict of interest situation did not imply that the entire appeal had to be abandoned. Dr. Ayine characterizes the prosecution of the ambulance case as a political witch hunt. I wholly disagree. The facts show that vehicles reporting to the ambulances were imported into the country in December 2014 in violation of the contract governing the transaction. In the absence of any request by the Ministry of Health, and at the time that the period for supply of the ambulances and the contract had even lapsed, Dr. Kessia Tufosin, by letters dated 7th and 14th August 2014, instructed the Bank of Ghana and the Controller Accountant General to issue letters of credit, which was the agreed means of payment for the vehicles under the agreement. The letters of credit were consequently established on 18th August 2014. Big C General Trading Limited, the suppliers to the vehicles based in Dubai, whose contract had no parliamentary approval, proceeded to ship the vehicles on receipt of the letters of credit. When the vehicles arrived, they were not of the kind specified in the contract and had serious defects with every material part of the vehicles, which rendered them unfit to be described as ambulances. Indeed, a John Mahama appointed Minister for Health at the time, Dr. Ayine, described the vehicles as ordinary vans, not fit for purpose. The defects were so irredeemable that from the time the vehicles arrived in December 2014 to January 2017, when the SR John Mahama administration left office, they could not be converted into ambulances. To date, they cannot be converted into ambulances, and the Mahama government is back in power. This view that the split 2-1 decision of the Court of Appeal, far from confirming Dr. Ayine's position that the case was flawed, was erroneous, and the Republic's chances of having same set aside by the Supreme Court was very high. If Dr. Ayine was convinced that his position would prevail on appeal, why did he not allow the appeal to run its course for a vindication of his views? What did he or his former client, Dr. Tufosin, stand to lose by the intervention of the appeal by the Supreme Court? Ladies and gentlemen, I observe that the real reason for discontinuance of the appeal by Dr. Ayine was that he did not wish to deepen the wounds of Dr. Tufosin any further. Republic versus Ofunsuampo for another. Dr. Ayine did not advance any reason whatsoever for the withdrawal of this matter, saying that he was on record as counsel for the defense. I have already pointed out above the absurdity of such a position, and I will not recount. The self-serving nature of Dr. Ayine's decision is too apparent for the people of Ghana to see. The Republic versus Collins, Dowda, and 5 and 4 others. The reason advanced by the Attorney General for the entry of non prosecution in the case filed against Mr. Collins, Dowda, and 4 others for their roles in the Sagame housing scheme view, the charges were defective. He claimed that the prosecution wrongly charged the former minister Godfred with the offense of misapplying public property, i.e. funds, in the sum of $200 million United States dollars. In Dr. Ayine's view, the prosecution should have taken into account the fact that part of the $200 million was used to construct the houses at Successor. With the greatest respect, this analysis by Dr. Ayine portrays a complete misapprehension of the ingredients of the offense of misapplying public funds. The offense of intentionally misapplying public property consists in wrongly applying public property, which is defined under the Public Property Protection Act of 1977, SMC Decree 140, for a purpose other than as lawfully approved. It is different from the offense of willfully causing financial loss to the state, whose defining ingredients is the actual loss occasioned the state through one's lawful act. In this case, Mr. Godfred was charged with the offense because he intentionally misapplied the sum of $200 million for the construction of 1,412 housing units instead of 5,000 housing units lawfully approved by the Cabinet, the Parliament of Ghana, and the Public Procurement Authority to be constructed. So the question of how much was disbursed by the state during Godfred's tenure as Minister for Works and Housing, or the exact amount spent in the buildings when he was minister, is immaterial. The real question is whether Godfred authorized the application of the sum of $200 million for the purpose lawfully approved for the project, i.e. the construction of 5,000 housing units. The answer to this question can only be in the negative. I say that in any event, if the attorney general of the considered view that the sum of $200 million mentioned under the count of misapplying public property should have been $94 million, all he had to do as a good prosecutor, acting in good faith, was to amend the count. The remedy is not a discontinuation of the entire case, especially when that offense of misapplying public property constituted only one out of 70 charges filed in the case. What happens to the other 69 charges that Dr. Ayine does not fault and did not talk about? With the greatest respect, the state should be seriously worried if her Attorney General demonstrates such ignorance of the basic principles of criminal law and the ingredients of offense, which border on the protection of state funds or public property. The second factor cited by Dr. Ayine for the withdrawal of the Sagleme case is the alleged failure of the prosecution to charge other ministers who took office after Collins Dowda left office. This is another palpable falsehood. The state charged all those whose roles in the Sagleme housing scheme implied criminal liability. This included Kweku Adjumah-Mensah, who signed and authorized the payment of money and who was John Mahama's Minister for Works and Housing after Collins Dowda left office until January 2017. It also included a Chief Director, Alhaji Ziblin, who was in office until 2017, covering a part of the tenure of Mr. Atachia as minister, and signed and authorized payment of money. Dr. Ayine raises issue with the failure to join Honorable Samuel Atachia as an accused person in the matter. It ought to be made clear that the prosecution of crime is not an arena to achieve political equalization. A careful check on the facts would have disclosed to Dr. Ayine that Honorable Samuel Atachia never authorized any payment for the Sagleme project. Mr. Atachia was rather the one who called attention to the bizarre circumstances of the project and wrote a letter seeking the advice of the then Attorney General before in or about 2019 for an urgent termination of the contract, a decision which stopped the state from unnecessary financial hemorrhage. The sum of $5 million that Dr. Ayine alludes to was authorized to be paid by the then Chief Director, Mr. Solomon Asola, and not Mr. Atachia. The decision by the prosecuting team not to charge Mr. Solomon Asola, but rather to use him as a prosecution witness, was because an examination of the record showed that Mr. Asola, in truth, tried to save the Sagleme housing project from total collapse. The sum of $5 million was authorized by Mr. Asola to be utilized for the project to save the project. Further, he assisted in shedding light on the relevant parts of the project. Hence, the prosecution's decision to use him as a prosecution witness. Prosecution of Dr. Johnson Pandit Isiama. The narration given by the Attorney General about why he is continuing the two different cases against Mr. Johnson Pandit Isiama again disclosed a litany of untruths, half-truths, and a skillful manipulation of the facts. Be that as it may, as it is with any manipulation of facts, the truth is always laid bare on being subjected to careful analysis. The first case involving Mr. Dr. Johnson Isiama Pandit, Dr. Johnson Pandit Isiama, is the Republic versus Communal before and others, a Yoruba case. This case involved an approval by Dr. Johnson Isiama of the sum of 450 million Ghana cedis for the benefit of the Universal Merchant Bank, UMB. Part of that sum was 300 million Ghana cedis, which was an unsecured facility approved by Mr. Johnson Pandit Isiama for UMB for the benefit of Bank Ghana Limited. The sum of 300 million cedis formed the basis of a charge of making approval in contravention of the Bank of Ghana law. The remaining amount of 150 million Ghana cedis formed the basis for the offense of willfully causing financial loss to the state. It is necessary to state that contrary to Dr. Ayine's claim, the sum of 150 million Ghana cedis to date remains unrecovered. I must indicate that I find the line of thinking of Dr. Ayine that simply because an alleged loss in state is recoverable after the offense has been committed or the charge found, the offense of willfully causing financial loss is rendered invalid, very strange and insupportable in law. Also, an amount paid in violation of the law, when subsequently recovered, does not clear the person who gave the approval to be made of wrongdoing in the first place. The anchor of Dr. Ayine's explanation for discontinuing the case against Johnson Pandit Isiama is a memorandum allegedly delivered to my good self by attorneys of the Office of the Attorney General, reported as Dr. Ayine stated, and I quote him, recommended that the charges against him be dropped. End of quote. Let me state for the record that, to the best of my knowledge, no such memorandum exists. No such memorandum exists. I do not recall receiving any such memo from the prosecution's division. I challenge Dr. Ayine to produce such a memo for the examination of the public, as he has started saying to the public at a press conference conducted by him as the basis for his improved actions. Curiously, when probed further on that issue in the question session of the press conference, Dr. Ayine claimed that I might have disagreed with the memo, and that is yet to know the exact reasons I made, or the exact comments I made on the memo. This is bewildering, and thus gave doubt on Dr. Ayine's assertion that the memo was presented to me on the issue. Will my comments on the position I took on the memo not be expressed on the memo, as is usually the case in every public service institution? How can Dr. Ayine see the memo but not see my comments in the memo? Clearly, the Attorney General set out to throw dust into the eyes of the Ghanaian populace, who in his view are a bunch of unethical people. Ghana deserves better than the tales of Dr. Ayine. Assuming for argument purposes that the memo was prepared for the consideration of the former Attorney General by some state attorneys whose ranks the current Attorney General does not specify, and on a date it does not indicate, is such a memo, I ask, binding on the Attorney General? Is the view of the state attorney binding on the Attorney General? Dr. Ayine himself alleges that he had some discussions with the DPP before withdrawing the cases in question, and that when he disagreed, he made it known to the DPP. Was the DPP's view binding on Dr. Ayine? I ask. I further ask, was it not his view, Dr. Ayine's view, of the charges he withdrew, which prevailed? If Dr. Ayine could form a view of the charges he withdrew from the court, in spite of what the DPP told him, how can he castigate Godfred in the media for whatever views Godfred took on the memo allegedly presented to him by some state attorneys who Dr. Ayine cannot name, on a date he cannot specify, and affecting some accused persons, again, he could not specify. And I say this because there are 6 accused persons in the matter. The question is, did the memo touch on all the accused persons? Dr. Ayine fails to indicate. I say that Dr. Ayine should, with the greatest respect, be bold to accept full responsibility for his actions and withdrawing and filing no protocol in all the cases, rather than purporting to blame former Attorney General for his decisions. The Public versus Johnson, Pandit, Isiama, and 5 others, the Unibank case, the UT Bank case. Dr. Ayine lumps up the 2 cases against Johnson, Isiama, and contends that the alleged memo presented to the former Attorney General, my good self, which discussed the amount of 450 million Ghana cedis, the subject matter of charges against the gentleman in the Unibank case, also covered the UT Bank case. This is another falsehood. The sum of 450 million Ghana cedis was in respect of only the Unibank case. The UT Bank case involved the grant of approval by Dr. Johnson Isiama of 460 million Ghana cedis facility to UT Bank in violation of a single of the goal limit. Be that as it may, it suffices to note that Dr. Ayine provides absolutely no justification for a withdrawal of the charges in the UT Bank matter, save the allegation that an alleged memo was presented to me. It is also important to note that the Attorney General considers the simple fact that the prosecution had closed its case in the UT Bank case. Thus, by virtue of the notice of withdrawal filed by the Attorney General, Dr. Dominic Ayine, Johnson Pandit Isiama was acquitted and discharged of the crimes that he had been charged with. Dr. Ayine therefore secured through the back door a whitewash and clearing of the sins of Johnson Pandit Isiama forever. The Public versus Stephen Opuni and 2 others. The reasons given by the Attorney General for the withdrawal of the case against the 3 accused persons in the Stephen Opuni case and the consequential whitewash and cleansing of sins through an acquittal and discharge again recounts the misconceived perspective of defense lawyers on the charges. That case involved the loss of 271 million Ghana cedis to the state. Once again, the media would observe that the Attorney General only presented to the public the series of stories that had formed the line of defense of counsel for the accused, but completely abandoning the formidable case built by the prosecution. The Attorney General completely disregards the fact that the prosecution had been adjudged by all the courts, the Superior Court's architecture, the High Court, Court of Appeal, and the Supreme Court, as having established a case for the accused persons in that Opuni case to answer. Indeed, Dr. Opuni had closed his case. Said Agungu had called about 10 witnesses. Dr. Ayine, in the face of the holdings of the various courts, that there was a case for the accused persons to answer in respect of the over 27 charges filed in the Opuni case, proceeded to embark on a scathing attack on the work of the prosecution's division of the Office of the Attorney General, over which he is now superintendent, as a ruse to justify the withdrawal of the case. A simple question that begs for answer is, why would the Attorney General, who is supposed to be acting in the interest of the Republic, be arguing strenuously in favor of the Defense Counsel and against the Republic, when all the Superior Courts had stated that Dr. Opuni and 2 others had a case to answer? If the new Attorney General was of the view that the accused had a strong case and would be acquitted, why did he not wait for the accused to establish this through a trial? Is it the case that counsel for the accused told him, after his extensive discussions with them, that they were not sure of securing the acquittal of their clients, and therefore they would prefer the Attorney General to bail them out through a withdrawal of the charges? Fellow Ghanaians, in purported rationalization of the government's decision to withdraw the Opuni case, the Attorney General most bizarrely attacked the integrity of a retired Justice of the Supreme Court, Justice Clement Onyeliba, and the Honorable Chief Justice, albeit unjustifiable. Dr. Ayine claimed that a perjury application filed by Dr. Stephen Opuni against a witness was not heard by Justice Onyeliba, and that, in his words, this is most unacceptable. Regrettably, this is another falsehood Dr. Ayine's first statement. The trial court ruled on the application that the applicant proceeded to the Court of Appeal by filing a notice of appeal. I repeat that the tendency of an Attorney General to make untruthful allegations against the prosecuting team and judges sitting on cases being prosecuted by his office is highly unprofessional. What we see, and this is exactly what we see from Dr. Ayine 3 weeks into his tenure. His actions constitute an attack on the very office he is now head of. Dr. Ayine stated further his press statement, and I quote, "When in accordance with law and practice, Justice Anochi Jima decided he was going to hold a de novo trial in the same Okuni case, he was instantly transferred to Kumasi, and the case was allocated to a new judge who then proceeded to adopt proceedings." End of quote. This is another plain falsehood, and a rehash of the unfounded allegations made by NDC commentators in the media space. If Dr. Ayine had taken pains to examine the file in Okuni matter, as he should have done, he would have found that it was not a new trial judge who adopted proceedings for the trial to continue. The then Attorney General, my humble self, was compelled to file an appeal against the order of Justice Anochi Jima for the proceedings to start de novo or afresh after they closed the prosecution's case and the defense had opened their case. The Court of Appeal allowed the Attorney General's appeal and ordered that the proceedings be adopted before the trial court. It took about 3 months for the appeal to be heard and determined. Before the conclusion of the appeal, the Honorable Chief Justice, in exercise of her powers under the Constitution, at the time that the proceedings of the matter had effectively been stayed due to the pendency of the appeal at the Court of Appeal, transferred the trial judge, Justice Anochi Jima, to the High Court, Kumasi. At the time that Justice Anochi Jima indeed had not even started hearing the matter at all. The display of unfamiliarity by the current Attorney General of facts regarding cases he withdraws from the various courts and speak about in the media is shocking. Ghana must be seriously worried. Ladies and gentlemen, in conclusion, I say that I deem the press conference hurriedly assembled by the Attorney General, Dr. Dominic Ayine, as a knee-jerk reaction to genuine concerns raised by well-meaning Ghanaians on the attempt by the NDC government to whitewash the crimes of persons who served in the NDC government, and as far as the law would allow, close to them with perpetual immunity from being prosecuted for crimes committed against the Republic of Ghana. The poster adopted by the Honorable Attorney General threatens to undermine Ghana's democratic and good governance structures. I'm however reassured by the fact that Ghanaians are discerning enough to discover the illegitimate motives that is continuous with the cases in question. The President, through his Attorney General, has in a spectacular fashion become the clearing agent to indemnify their allies who have duly been put before the court for commission of crimes. Thank you very much. God bless us.